Hello, everyone. I hope you and your family are keeping well and safe during these difficult times. I'm Rupinder Malik, M&A White Collar Practice Partner, and I would like to welcome you all to the first round of JSA Associates COVID-19 Legal Broadcast Series. Well, we've been receiving a lot of calls and queries in connection with COVID-19 and its impact. So I guess these sessions are going to provide relevant information at a time when we know our clients are dealing with multiple issues, unprecedented business scenarios, and need quick answers. Today's topic is M&A and financing transactions. My partners who are experts in this subject will be sharing their thoughts with us. So let's start with Sidharrth, our M&A and private equity partner. Given the COVID-19 pandemic, we of course expect some changes in our standard process of due diligence and M&A transactions. And Sidharth, it would be helpful to hear from you your views on the key considerations for buyers when undertaking due diligence.
Thanks, Rupinder. Quantifying the impacts of the outbreak on a target will be challenging. The buyers will have to focus the diligence efforts on the following, in my view. The ability of the target and its counterparties to perform or terminate their obligations under the material contracts, any commercial renegotiations with counterparties under existing material contracts that are underway, or terminating their rights that may have already been exercised. Regulatory restrictions or applicable to the target company will require reviewing from an existing regulations perspective. The implementation of appropriate precautionary measures from an employee's health and safety, and any resulting regulatory and data privacy implications. We also feel that the necessity and the availability and the cost of alternate suppliers through target company's supply chain will be necessary for the buyer. The solvency risk and the target company's ability to service its debt and otherwise comply with covenants under its debt documents will have to be seen. Their existing insurance policies and their coverage, including business interruption policies and any other available lines of insurance, such as insurance issued to counterparties, will have to be reviewed during the due diligence. And general exposure of the business to jurisdictions which have been highly impacted by this outbreak becomes important. Last but not the least, I think the virtual diligence capabilities of the parties in this transaction, in the M&A transaction, will have to be made sure that they are in established protocols are in place.
This is very helpful, Sidharth, and I agree that there are multiple issues such as supply chain continuity and insurance that will need to be looked into. So my next question is to Vikram Raghani, who is also our M&A and private equity partner. So Vikram, talking about M&A deals, will COVID-19 qualify as material adverse change under M&A agreements? Over to
Thanks,
you.
Rupinder. Yeah. So whether COVID will qualify as material adverse change will largely depend on the drafting of the clause itself. Typically, a MAC clause would exclude global events which impact industries generally, unless these events have a disproportionate impact on the business. In such cases, an acquirer would need to prove that COVID has impacted the target company disproportionately, which will largely depend on the sector in which the company is operating and the impact of COVID on such sector. For example, it may be easier to establish such an impact on industries such as airlines, leisure, hospitality, which have obviously been impacted more than some of the others. There are no precedents or authority in India directly on this point. There are a number of issues which have to be considered. For example, does the clause have bright line tests in terms of thresholds for revenue or profits? If not, what constitutes a material impact and whether such impact can indeed be attributed to COVID? If the COVID crisis pushes a company to the brink of insolvency, or if an acquirer can establish that there would be a long-term impact on business and profitability, which alters the very nature of the transaction, a court or tribunal may find favor to such considerations depending on other facts. If there is no MAC clause, or if the parties have not contemplated a crisis of this nature, An acquirer could still terminate the transaction by invoking the doctrine of frustration. Under this doctrine, in the context of an M&A, if the impact of COVID strikes at the fundamentals of a deal or at the root of the transaction, an acquirer may still be permitted to walk away from the deal. Indian courts have consistently held that a doctrine of frustration cannot be used to walk away merely because the performance of a contract has become commercially onerous. As such, whether valuation-related issues or a temporary drop in business prospects on account of COVID amounts to frustration remains to be seen. Where the parties have specifically excluded COVID-type situations from a MAC, they would not be entitled to generally rely on the doctrine of frustration to terminate the agreement. And the ability of acquirers to walk away citing COVID will also depend to a large extent on the long stop date negotiated in the contracts. Inability to complete a transaction within a prescribed timeline can be a ground to terminate under Indian law. The general expectation is that COVID will be a short to middle term impact rather than long term. Therefore, acquirers with a nearer long-term long stop date will be better placed to trigger MAC on account of COVID rather than acquirers with a longer long stop date.
Many thanks, Vikram. So this will really depend on facts and circumstances of each deal, and also the specific terms, if any, agreed between the parties. That was helpful. So moving on to some financing aspects, I would like to ask my finance partner, Aashit Shah, if he could share his thoughts with us on COVID-19 related considerations, particularly in lending transactions.
Thanks, Rupinder. While the long-term impact of COVID-19 on the financial health of companies is difficult to imagine at this stage, in the short term, there could be an immediate impact on facilities that are still to be drawn down and facilities that have already been drawn down. Several borrowers may seek additional liquidity by drawing down on their existing working capital lines or undrawn term loans. Lenders receiving such drawdown requests will want to confirm that all required conditions for drawdown have been satisfied. For instance, most credit agreements include a solvency representation that needs to be true and correct at drawdown. Lenders must assess the correctness of this representation before disbursal. While almost all credit documents include a condition precedent on material adverse effect, the operation of this provision will vary based on the language in the contract. So parties should carefully examine if this can be used as a drawstop. Another common condition for drawdowns is the absence of any actual or potential defaults under the credit facility. Lenders will want assurance that no such defaults are existing as a result of the COVID-19 outbreak before dispersal. In relation to debts already availed, there are a few issues to keep in mind. COVID-19 will have a substantial impact on many companies' top lines and bottom lines, and this may either impact their ability to service existing debt or may adversely impact existing financial covenants which they have agreed with their lenders. This could trigger defaults. While the RBI has enabled banks, all India financial institutions, and NBFCs to grant a 3-month moratorium for any payments due between March 1st to May 31st, 2020, the moratorium does not apply to foreign lenders or certain types of bondholders. So these creditors may want to accelerate their debt. As a result, these borrowers will need to approach lenders for waivers or relaxation on certain conditions. Lenders must evaluate options on whether to accelerate the debt and enforce security or whether to restructure the existing debt. But before taking any decision, they should diligence their existing credit documents to ensure that they are adequately and duly executed and any security is properly created and perfected. And they should also analyze the remedies that are available to them under their documents as well as under law.
Thanks so much, Aashit, particularly for sharing considerations for existing debt and the conditions to draw down of existing commitments, as well as future expectations. This is certainly critical in the current situation. Another important aspect is insolvency, and for that, I would like to ask my another finance partner, Divyanshu Pandey, on whether there are any insolvency law-related measures taken by the government pursuant to the COVID-19 crisis.
Thank you, Rupinder. Like many other jurisdictions, such as Singapore, UK, and Australia, India was also quick in making concessions to its insolvency regime as soon as the COVID crisis hit India. One of the first measures taken by the government is to increase the threshold of default amount for initiation of insolvency proceedings from INR 100,000 rupees to INR 10 billion, almost an increase of 100 times. This measure has been taken with a view to prevent companies, especially small and medium enterprises, being pushed into insolvency on account of liquidity issues caused by the COVID crisis. Such measure is also helpful in decongesting the insolvency courts during this crisis. The government notification does not have a sunset clause, and it will be interesting to see if the government in future revises the default threshold to a lower amount when the COVID crisis is over. The other measure which has been taken is that given that insolvency resolution under IBC is a time-bound process, both Insolvency Board and the NCLAT acted swiftly to exclude the lockdown period for the purpose of calculating the prescribed timeline of 330 days for completion of the insolvency resolution process. With social distancing to be followed as a norm and courts entertaining only urgent filing, this measure has provided respite to all the stakeholders. Otherwise, many companies going through the insolvency resolution process may have had to face the prospect of liquidation because of the technical issue of process not being completed within the prescribed timelines. Lastly, not a relief in place yet, but it is anticipated that certain provisions of IBC may be suspended. The finance minister in her speech on 24th of March had indicated that as a temporary relief, the government could look at suspension of filings for initiation of insolvency resolution. This would mean that insolvency resolution cannot be initiated by a financial creditor or an operational creditor or even a corporate debtor itself. It has been reported that the government is working on an ordinance to grant such relief. If such a measure is taken, then it may have a flip side of diluting the discipline and credit culture brought by implementation of IBC. However, at the same time, one cannot lose sight of the slowdown and liquidity crunch caused by COVID-19. And it would be unfortunate if many companies end up in insolvency resolution process on account of business disruption caused by COVID-19. The details of such ordinance will have to be examined when it is in the public domain to understand the scope of the relief. And I believe only time will tell what impact it will have on success of IBC. Thank you.
Many thanks, Divyanshu. So while some measures have already been undertaken, there is still wait and watch for aspects like the possibility of suspension and initiation of fresh insolvency resolution proceedings. So moving on to my last question, I would like to go back to Sidharrth for an overview of potential implications of COVID-19 on the ongoing M&A transactions.
Thanks, Rupinder. I think this is interesting, and we've been seeing a lot of questions regarding this, but we feel that some of the things that will really impact is the pricing mechanism and the adjustments to purchase price, which will come across in these situations. So your traditional adjustments to purchase price, such as the net working capital, the indebtedness, will get impacted by this outbreak to some degree. Parties will go through the exercise of determining whether the outbreak related adjustments should be incorporated into the net working capital calculation or not. The CPs and the standstill provisions will undergo changes. Seller, for example, will assess the impact of the outbreak and actions required to be taken, the prior approval of the buyer. Need for new carve-outs for standstill provisions will come in. Seller will negotiate for appropriate waivers to the CPs, which are there as part of the M&A deals that they've signed. And there could be new CPs to mitigate the outbreak that could be asked by the parties. With respect to warranties, there could be a comprehensive assessment by the parties on the warranties due to this outbreak, and the buyers will seek warranties around risk assessments, business planning, and of course, the impact that the outbreak has had on the business. Sellers, in my view, will resort to knowledge and materiality qualifiers when it comes to warranties. And we would see the warranties insurance coming in for as an inclusion for such outbreak. With respect to disclosures, I guess the sellers will need to evaluate outbreak-related disclosures, for example, against specifically material contract warranties. There will be changes in the key dates, possible extension to long stop dates and closing deadlines, and the timeline for any purchase price adjustment mechanism may have to be reviewed. With respect to closing, we think that the situation where certain closing conditions where there would be moved as post-closing covenants, and there could be extensions of long stop dates or occurrence of termination event. That's all about it, Rupinder. Thank you.
Thank you so much. I hope everyone found this discussion useful. I would like to thank Sidharrth, Vikram, Aashit, and Divyanshu for addressing these emerging issues. And most importantly to our listeners, please do note that we will continue with legal coverage on COVID-19. And thank you very much for your support, and please stay safe and healthy. Thank you.